Morning. I'm calling this meeting to order. It's a public meeting on June 23rd held at Howe Island for a specific purpose. We'll begin this gathering by acknowledging and celebrating these traditional lands as a gathering place for the first peoples and their ancestors who are entrusted to care for Mother Earth since time immemorial. We do so respecting both the land and the Indigenous peoples who continue to walk with us through this world. Today, the Township of Frontenac Islands is committed to working with Indigenous peoples and all residents to pursue a united path of reconciliation. Is there any declaration of pecuniary interest in the general nature thereof? Seeing none, the purpose of this meeting is the application is to seek public feedback regarding the proposal to temporarily allow the housing of 2 horses, a shaded shelter, a shed, and temporary manure storage facility on an existing 0.33 hectare or 0.83 acre lot of record through a temporary zoning bylaw amendment. The temporary zoning bylaw would be in effect for a period of up to 3 years with an opportunity for extension in accordance with section 39 of the Planning Act background. Okay, now, who would you speak to this?
Thank you, Madam Mayor. Good morning, everybody. Thank you, Councilman, for being here. Members of the public, my name is Dimitri. I am a senior planner with the County of Frontenac. The county provides day-to-day planning services for the Township of Frontenac Islands. So my job is to provide council as well as township residents with land use planning advice and recommendations with respect to planning applications and planning matters in the context of the township official plan, provincial policies, and any applicable regulations that govern the use of lands within the township. Before I start my presentation, I need to go through a quick administrative matter. So I'm going to read the procedural statement for a public meeting under the Planning Act. So this morning, council will be conducting 1 public meeting under the authority of the Planning Act. This item includes the application for a temporary zoning bylaw amendment on a lot of record known as 11 Pickett's Lane. The following statement applies to the public meeting. Personal information collected as a result of this public meeting is collected under the authority of the Municipal Act, the Municipal Freedom of Information and Protection of Privacy Act, the Planning Act, and all other relevant legislation, and will be used to assist in making a decision on this matter. All names, addresses, opinions, and comments may be collected and may form part of the minutes that will be available to the public. Questions regarding the collection should be forwarded to the township clerk. Any person who wishes to receive a copy of the minutes of a public meeting, a copy of any planning report, or notice of council's decision of any of the applications should indicate their full name, address, postal code, and other relevant contact information to the clerk prior to leaving the meeting. If a person or public body does not make an oral submission at the public meeting or make a written submission to the Township of Frontenac Islands before council makes a decision on the planning application, the person or public body is not entitled to appeal the decision to the Township of Frontenac Islands to the Ontario Land Tribunal and may not be added as a party to the hearing of an appeal before the Ontario Land Tribunal unless, in the opinion of the tribunal, there are reasonable grounds to do so. Please note that only specified persons in the Planning Act are permitted to appeal zoning bylaw amendment applications. The procedure for the public meeting will be as follows. The planner will explain the purpose of the public meeting and provide a brief overview of the application and a summary of their review and recommendation. The applicant will then be provided with an opportunity to provide any comments they have about their application. Members of council will then have the opportunity to ask questions to the applicant and the planner. The chair will then inquire if there are any members of the public who wish to make an oral or written submission on the proposed application. If so, you should announce your name and mailing address before providing your comments. Please be aware that anyone wishing to address the applicants or the application should direct their comments and questions through the chair, who is the mayor this morning. So I'm just going to share my screen here and bring up the PowerPoint presentation.
Almost. There you go, please.
Okay, so the application, the lot that's subject to this application is located at 11 Pickett's Lane on, the legally described as Part Lot 6, North Range, Howe Island in the township of Frontenac Islands. The proposal is to temporarily rezone an otherwise vacant 0.33 hectare or 0.83 acre rural parcel to permit a farm use, specifically with the raising of 2 horses as defined by the township zoning bylaw, and to also permit the associated accessory structures needed to house them. That includes a sun shelter, a shed, and a temporary manure storage facility as defined by OMAFRA. The proposed temporary zoning amendment will be valid for a period of up to 3 years with an opportunity for renewal, or until the subject horse passes away, or until the property owners sell the lot, whichever comes first. From a technical standpoint, the zoning is proposed to be changed from rural to Rural Temporary Zone 1 or RUT1. This amendment is being submitted in an attempt to resolve an existing zoning bylaw compliance violation. The applicant has created what's called a dry lot to house 2 horses on an otherwise vacant parcel. The purpose of a dry lot is to provide a controlled environment that is free of all natural vegetation for horses that have a medical condition. These horses specifically have a medical condition that prevents them from properly metabolizing or digesting the sugar content found in regular grass. The applicant's horse has this medical condition and requires a dry lot in order to keep itself up to standard. The dry lot consists of a 14.8 square meter or 160 square foot horse sun shade shelter, a 8.9 square meter square foot, 96 square foot shed, and a 5.6 square meter or 60 square foot temporary manure storage facility, which is essentially a covered waste bin that holds the manure that's produced by the horses. This is a site plan of the subject property. The dry lot in question is outlined in red. Inside of that dry lot is a sun shelter. Beside the dry lot is a shed, and the manure storage bin is located on the northwest side of the property, close to the intersection of Pickett's Lane and Howe Island Drive. So I took these photos when I visited the property in early spring. As you can see, there was no vegetation at the time. So the photos presented here kind of show what the property would look like for most of the year when there is no vegetation. This is a picture looking down Pickett's Lane from Howe Island Drive, with the subject property being on the right-hand side. What you see is in the middle of the screen is with the slanted roof, that's the sun shelter, and to the right is the storage shed. This is another picture of the sun shelter with the sloped roof. One of the horses you could see on the right-hand side of that sun shelter. And the other side of the shelter, the interior of that shelter, is shown in the image to the right. This is an open building, so basically horses can come in and out. They're not really housed in there. The horses are able to move around the dry lot. There is no barn on this property as you would typically define one. The manure is stored in the bin on the image to the left. It is a dumpster pretty much, or a dump container that is tarped to prevent rainfall from coming in. This bin gets emptied once it is full on another agricultural property elsewhere on the island, and of course it's used as manure. On the bottom right-hand side is a photo of the property looking from the south side. So we're on the edge of the property on its southern extent, looking towards Pickett Lane. So in terms of feedback, the applicant had submitted 3 letters of support from members of the public. One of the 3 is an adjacent neighbor that's closest to the subject lot on the east side on Pickett's Lane. We also received a letter from a veterinarian confirming that the dry lot is suitable for the horses and the horses are in good health because of this dry lot. And we also received comments from the Ministry of Transportation stating that they have no concerns regarding this application because it's outside of their development review in their regulated area. So why is a zoning amendment needed in this situation? So the subject that is zoned as rural. Under the township zoning bylaw, the raising of horses fall under the definition of farm or farm use. If you have a property and you want to establish a new farm use, that's as defined by the zoning bylaw, on a rural zone lot, you need at least 10 hectares or 25 acres of property with a minimum frontage of 200 meters or 656 feet of frontage. The subject property is 0.33 hectares or 0.3 acres with about 61 meters of frontage. The township zoning bylaw provides no exceptions to small scale agricultural farm uses, hobby farms, or the keeping of large animals as pets. Similarly, the township has no other bylaws that regulate or govern the keeping of large animals, pets on a property that is not under agricultural production. So what is a temporary zoning bylaw? Under section 39(1) of the Planning Act, there is a permission that allows council to pass a bylaw to authorize a temporary use of land, buildings, or structure for any purposes that is otherwise prohibited by the township zoning bylaw. Under section 39(2) of the Planning Act, the temporary zoning bylaw comes with a 3-year time limit for any temporary zoning bylaw amendments that are passed under the previous section. The section 39(3) allows council to extend the temporary zoning bylaw for an additional 3 years after the first 3 years has passed by passing a bylaw. What section 39 does not do is give applicants the right to continue their use once the temporary period has lapsed, unless it's renewed and through the passing of a bylaw by council. If the applicant wishes to make the use permanent, a zoning bylaw amendment that will need to be passed under section 34 of the Planning Act would then need to be applied for and passed for this use to become permanent. So on this slide is a draft temporary use bylaw. So this is the wording of the bylaw. What it essentially translates to is that if this was to be approved by council and this bylaw becomes law, that the temporary zoning bylaw would be valid for up to 3 years or until the horse named Whistler passes away or is permanently removed from the property, or until the property is sold to another person, whichever comes first. So staff will consider feedback at this public meeting and return to council with the recommendation at a future date, meaning no decision will be made today. The purpose of this meeting is simply to seek feedback from residents, ask any questions, to clarify any matters associated with this issue. I'll now take any questions if you have. Thank you.
Okay, just check with the clerk, and then I think we start with questions from the.
No, you would start with council and then.
And one more thing, we also need to give the applicant an opportunity to provide their statement if they wish to do
So
that.
that should probably go first.
Sure, yeah.
Okay. With the applicant, Rita, I'd like you sit there, introduce yourself and your location that you lived.
All right, this is what I'm going to cover, if you want to pass it on. It's just what councilors already have. And Mayor, Deputy Mayor, Councillor, Senior Planner, and interested public. Thank you for attending the meeting. Rob, my husband, and I appreciate you taking the time to be here. I'm going to leave some.
Can you just say your name and your address for the record, please?
Rita Kiesla, 11 Pickett Lane, Howe Island.
Thank you.
We're here to request a temporary zoning bylaw amendment for our property at 11 Pickett Lane. We have lived on Howe Island as permanent residents for 17 years. I have a 22-year-old horse, Whistler, and he's been with me for 20 years. In 2016, he foundered, another term is laminitis, at a boarding facility. The cause of the laminitis was pasture grass. Subsequently, he was diagnosed with insulin resistance and pituitary part intermediary dysfunction, also known as PPID or Cushing's. Insulin resistant is a condition that affects a horse's ability to regulate insulin, much like a diabetic. PPID affects the pituitary gland, and basically he has a benign tumor in the brain. Both conditions are associated with increased risk of laminitis in horses and ponies. When horses like Whistler eat grass or binge eat on rich hay, the starches and sugars in the grass or hay can spike their insulin levels, quickly and result in laminitis. Laminitis is an extremely painful condition, severely damaging long-term. Horses like Whistler, who are unmatched, will continue experiencing this terrible disease, and in some cases may have to be euthanized. Medication, diet, weight management are needed to effectively prevent laminitis and maintain a healthy horse. My responsibility is to provide careful and effective management of Whistler's medical conditions to prevent laminitis from happening again. This entails a vegetation-free living environment, daily administration of medication or medications, and twice daily hay feedings. The most effective way to avoid triggering a laminitic episode is to provide a safe area with no grass or other sugar and starch-rich foods for Whistler and Marcel. Marcel is the pony that was introduced in the winter. Veterinarians and farriers alike prefer to have these horses on dry lots to avoid the grass issue altogether. Following Whistler's initial diagnosis of laminitis in all 4 feet, he needed to be moved with 1 month's notice from his boarding facility of 12 years because the barn manager could not accommodate his needs, which is provide a dry lot and feed a hay-only diet. After a frantic search for a boarding facility with a dry lot in Kingston and surrounding areas, I managed to secure temporary boarding for an agreed-upon term of 1 year. It takes a year to grow a healthy foot again. 3 months prior to the end of that year, I again pursued dry lot availability in the surrounding area to no avail. As it happened, an acquaintance offered land for me to build a dry lot in exchange for chores. 5 years later, it was necessary to seek another boarding facility due to her advancing years. That's how boarding facilities go. I was fortunate enough, or Mary Monroe was kind enough, to offer space at her facility on Howe Island, where I provided twice daily care for Whistler over the winter months. However, in the spring of 2023, some of her own horses required the limited space available. Again, with few options and limited time available, I looked into the possibility of having a dry lot on our property on Howe Island. Searching for adequate dry lot accommodation has been a 9-year struggle. We have a 1 acre separate lot, part lot 6 North Range, that is zoned as rural. After much research of the Township of Frontenac Island policies and zoning bylaws, I contacted the County of Frontenac to inquire about the possibility of developing a dry lot on our property. For 3 weeks in April 2023, I had extended phone conversations with Justin King of the Planning Department and he with his supervisor. The main focus of our conversations was the 10 hectare, which is approximately 25 acres regulation. I explained the reasons why Whistler needed to be on a dry lot and the fact that there was a lack of available or suitable dry lots in Kingston and areas. I also clarified why 10 hectares was in Utah, given Whistler's medical condition. Even if we owned 100 acres, they would be unusable. Our separate lot, approximately 1 acre, provides more than enough space for Whistler and has no immediate needs. Mr. Kane verbally confirmed he and members of the planning department concurred that 1 acre should be sufficient given the circumstances. He also asked me to make sure Howe Island councillors were on board. I talked with both Councillor Bob Ackley and Township staff Mike Finn, acting at the time, communicating that County of Frontenac planners have given verbal approval to build a dry lot on our property and needed the concurrence of Howe Island councillors to proceed. Bob and Mike basically said the same thing. It's your property. With verbal approval from the County of Frontenac planners and support from Howe Island Councillor, I moved forward to the development of the dry lot. In fact, showing his support, Councillor Ackley helped in the development of the dry lot by removing huge rocks with his skid steer. The dry lot was designed to minimize any effects on neighbors and Howe Islanders alike. In doing so, several factors were considered, including neighbors' concerns, location, size, fencing and shelter, footing material, odor and manure management, and aesthetics. Before the dry lot was constructed, an email was sent to the neighbors on Pickett's Lane describing the situation with Whistler and my intent to build the dry lot. I asked if there were any concerns to please contact me. I received nothing but support and no opposition to my plans for the dry lot. There are no neighbors abutting this lot. It is surrounded by vacant township property on the east and south sides and Howe Island Drive to the west. The dry lot allows more than adequate space for Whistler and Marcel to move freely, drink, eat, and socialize. The dry lot is a third of an acre or 15,000 square feet of turnout space. The normal space requirement for an average size horse on a dry lot is 1,000 square feet. My dry lot provides more than adequate space for even 2 horses. Sean Finucane, DVM, provided a written statement to council as follows. I am the regular attending veterinarian for Rita Heaslip's 2 horses located on her property on Howe Island. The dry lot and shelter provided for these 2 horses are in excellent condition and are perfectly suitable and adequate to properly accommodate the 2 horses. Both animals are in good condition. The fencing is solar powered, electric, and safe. It is tall, signed, and easily visible. The 10 by 16 foot shelter is spacious for a horse and pony and provides protection from inclement weather. The dry lot is located on a flat, well-drained area on the south side of the lane. There are 2 sections with different footings. The area closer to the laneway has 6 to 8 inch surface layer mix of stone dust and masonry sand. The other area is treed, natural topsoil, void of grass. I know proper odor and manure management is critical to the housing of horses and its impact on the environment. If not properly managed, manure can contribute to water pollution through runoff and nutrient loading in nearby waterways, especially if there is poor drainage. To minimize this, I am diligent with regular cleanups of manure. I have an enclosed commercial bin, as you've mentioned, lined with industrial tarps for manure storage. When full, the bin provider removes the bin, dumps the manure at a location on Howe Island, and returns the empty bin. This greatly minimizes nutrient loading in the soil. Flies are a pest to horses in any living environment, and the removal of manure and preventing standing water from accumulating in the dry lot supports effective fly control strategies. Anyone who has dropped by to visit with me and the horses knows that flies are not an issue. The aesthetics is best summarized by my farrier, Sarah McFarland, in a document submitted to council. Whistler Marcel's dry lot is one of the most beautifully laid out and managed I have seen in my 30-year career. My main reasons for this opinion are the excellent drainage and easily cleaned substrate installation that forms the base of the plant. The safe location and base of the shelter, rubber matted for easy cleaning. The section of the smaller paddock in the southwest corner can be closed off or open, providing a second interesting space surrounded by a great windbreak of trees. And interesting scenery to provide mental stimulation to the horses. The safety and security of the fencing is better than most of what I see in my travels. Highly visible to the horses and pedestrians, aesthetically pleasing. Mrs. Heaslip has also continued to add to the property lovely landscapes of wood chips, shrubs, small trees, and garden features external to the paddock. End of quote. I'm proud of the facility and welcome anyone to come and visit. At some point after the dry lot was in use, we were visited by bylaw officers. These bylaw officers were apparently responding to complaints from the public. The first complaint involved setbacks for the fencing. Following inspection, the fencing was approved as is. The second visit was very vague, basically dealing with the complaint that a horse was there. The bylaw officer stated the horse had to be removed immediately. The bylaw officer was asked to put this in writing. There was no follow-up. On the third visit, bylaw officer Marcel Levine stated he had a complaint that the horse shelter was oversized. He measured the shelter and found it to be in compliance with the building code and did not require a building permit. In fact, he said he was impressed with what he saw. Over a year later, we received an email from Marcel Levine on March 27, 2025, referencing zoning bylaw 4.18.3, stating the minimum lot area was not being met. We contacted Mr. Levine about how to proceed, and he directed us to the County of Frontenac Planning Department again. On the advice of Dimitri, senior planner, we completed an application to amend the zoning bylaw, basically to formalize the previous verbal approval that we received from the planning department in 2023. It would appear, and this is important, that the complaints are coming from the same source or sources. We have had nothing but support from friends and neighbors, and since the source of the complaints has remained anonymous, we don't understand what the purpose of the complaints actually are. Given that the complaints are not coming from someone who would be directly affected by the dry lot, and given the persistence of the complainant, it would appear that the bylaw system has been used to harass us, and we have no idea why. Since the dry lot has been in place, there has been nothing but positive feedback to us personally and unexpected benefits, including employment for a high school student from the island, people requesting manure for fertilizer off and on island. People have altered their walking route to visit the horses. Parents and grandparents bring little ones to connect with the horses. Howe Island is an agricultural island, first and foremost. Being greeted by two horses sets an agricultural tone for the island, and it gives islanders something to talk about. A personal note. It would be our preference to believe that municipal councillors observe and act with the highest standard of ethical conduct and integrity. However, it is evident to us that this has not been upheld in this case. We are thoroughly disappointed with the way Howe Island councillors have handled the situation. The long-standing saying, "the squeaky wheel gets the grease," is very evident here. Our councillors listen to the complainants without any consideration for the individual complained of. To date, neither councillor has talked with us specifically about legitimate concerns and or sought solutions to rectify those concerns. In fact, they haven't even taken the initiative to come and inspect the property personally. This is a clear implication, however, that we have done something wrong or undesirable and need to be punished for it. Councillors' actions strongly suggest that complainants' rights are to be acknowledged and not that of the individual complained of. It greatly concerns us that councillors have already communicated to us and other Howe Islanders that they have made up their minds not to support the application, even though they had yet to see the results of the planning study. And Dimitri, is this the first time the planning study has been presented?
There's been no recommendation from planning staff prior to
Okay.
this.
Or to hear the information being presented in this meeting, whether intentional or not. Councillor Ackley's actions over the past few months have resulted in me feeling desperate and despondent. For example, he told me, "I'm going to lose both horses. The mayor will never vote for me. The deputy mayor will not support me." He has accosted friends and neighbors asking if they support the dry lot, but rather than pursue their positive responses, he proceeds to negate their support with opposing arguments. For example, she's wasting her money. There are many other incidents that I could list, but they don't add to the purpose of the meeting. Gossip and rumors spread quickly, and it is our belief that Councillor Ackley's actions highly suggest that he has assured complainants, he's made promises, he's shown favoritism, that the dry lot horses would soon be gone without regard to the facts. I'm asking you, how is this fair or unbiased? These unethical tactics, again, whether intentional or not, are very hurtful and have caused unwarranted stress. Let's not forget, Whistler has been part of our family for 20 years, and for the past 9 years, he has been sound and healthy for, excuse me. Two reasons. His medical condition
Take your time.
has been well managed, and he lives over for a lot. Thank you. Rob is going to talk to you about how the 10-hectare regulation is a red herring.
Thank you for that detailed description of the district.
Madam Mayor, can I just,
Yes,
pop in? I just want to add one point of clarification. So, Justin Kane, is not a county planner. So Justin Kane was employed by the township at the time. He may have consulted with, planning staff, county planning staff, at the time that this issue came up. But I just want to, for the record, to state that Justin Kane is A, not a planner, B, not a county employee. Thank you.
and just for clarity in that, all members of the council are equal in voice. So everybody gets one vote, it's not decided one way or the other, that should ever be. Invite you, please. We have somebody else going to present
Yes, I'm
to
done.
us.
What you, prove. I think. This, application should be approved.
Okay, sit down, state your name and your location, please.
My name is Rob Eastwood. I'm Rita's husband for 52 years. And I also live in Pickett. That's a hard act to follow. I'd also like to thank everybody for attending. I'm surprised at how many people showed up. I didn't expect this at all. Before I make my presentation, I'd like to address what Rita said there. I hope you all understand that the pressure that she's been under. Rita's very close to her horse. There's no exaggeration to say that Whistler has for years been the center of her life. If you go on YouTube and search Rita Eastwood, you'll be able to view some of the adventures that Rita and Whistler have had together. When Whistler was affected with laminitis and almost died, Rita spent a whole year nursing him back to health. As Rita has described, she thought she had done everything correctly and got proper approval. And then all of a sudden, we get a complaint and people start questioning us. And it's been very, very difficult. Okay, so that, I'll get into what I'm really here to talk about, which is the amendment. I'd like to thank Dimitri for his great presentation there. However, I disagree with a few things. I'm not gonna read this verbatim because it probably take too long. But in my opinion, the requirement for 10 hectares or 25 acres is a misinterpretation of the zoning bylaws. And here's how I figured that out. I'm an engineer. And so and I'm still working, even though I'm 75 years old. And what I do is I design chemical plants. And I use artificial intelligence in my research. specifically, co-pilot. So I thought, this 10 acre thing doesn't make any sense. Because it means that if anybody wants to say build a greenhouse, they need to buy 25 acres of land to put the greenhouse on. Because the greenhouse is an agricultural. So I'm saying, I'm thinking, if it doesn't make sense, it's probably not right. So I went to co-pilot and I asked, why is there a 10 acre requirement, or a 10 hectare, I'm gonna say acres from now on, 25 acre requirement. And co-pilot told me that it was because the Ontario government, Department of Agriculture, recommends that any time that a severance takes place in a farmland, that it be a minimum of 25 acres in size. Okay, so then I is it permissible to use a plot of land under 25 acres for agricultural use? Right? And co-pilot said, yeah, you can. Of course you can. But 25 acres is 1,000 feet by 1,000 feet. It's a big plot of land. And if nobody is allowed to use it for agricultural use, if they own that property and they're not allowed to use it for agricultural use, it just doesn't make any sense at all. Well, anyway, well, yes, a rural lot can be used for agriculture even if it's under 25 acres, including the township of Frontenac Islands. There is no province-wide minimum lot size for agricultural use in Ontario. In many rural zones, small-scale farming, market farming, beekeeping, or raising a few animals are permitted uses, even on lots as small as 1 or 2 acres. Okay, so I said, all right, that's fantastic. That said that we are not in violation of the zoning bylaw. Well, I said, first of all, I wanted to know where this information come from, because it's different than what everybody has been telling me. And it seems like it's different than what everybody believes. And so it told me that it came from, and this is actually very important, it came from the Government of Ontario Agricultural Department, the Township of Frontenac Island zoning page, but the third one is what it looks at the planning practices of all of the townships, all over Ontario, and how they have interpreted this rule. Right, if you just read the zoning bylaws as they're written, it says 10 hectares. But how has that been interpreted across the whole province? It doesn't even make sense, but how is it interpreted across the whole province? So I asked, is a 1 acre lot designated rural use suitable for agriculture use in the Frontenac Islands Township? And the co-pilot answer, the AI answer is, yeah, a 1 acre lot is designated as rural use in the Township of Frontenac Islands is suitable for agricultural use, which raising horses is agricultural use. The bylaws do not, the zoning bylaws do not make any distinction between the different types of agricultural uses, like the growing corn or raising horses or doing anything. It's all the same. The only difference is when it comes to the odor management, manure management, and setbacks. If you got a 100 acre farm, you still have to meet the setback, right? Okay, so It goes on to say, no minimum size specified in bylaw for general agricultural use, that's where I disagree. Sorry. So even a 1 acre parcel can qualify. Okay, oh, that's great, except for everybody believes that you need 25 acres. But I've talked to, so I asked Copilot, the AI, why? What was the exact question? How does this jive with the 10 hectare requirement? And Copilot says, great question, because the 10 hectare figure often causes confusion. In Ontario, the 10 hectare threshold typically comes up in the context of lot creation or severances in prime agriculture areas, not as a minimum size for agricultural use itself. Then the Department of Agriculture guidelines confirm that in the township of Frontenac Islands, according to co-pilot's understanding, there is no minimum lot size for agricultural use in the rural zone. So if you own a 1 acre lot, you can use it for small scale farming. Okay, so basically what it comes down to is that 10 hectares is the guideline for a new lot creation. And there is no minimum for existing rural lots used for agriculture in Frontenac Islands, and as a matter of fact, anywhere in Ontario. Unless there's a specific bylaw that prohibits it. Okay, so I've gone on here to ask how can I prove to everybody that this is the case? And Copilot gives me a really good outline of how I could do that. First of all, it says there a guideline, Ontario guideline. Second, you have to show your agricultural plan, which the reader has just done very well. Site precedent, Ontario Federation of Agriculture supports small scale farming and recognizes its role in rural economies, and many small farms in Ontario operate successfully on less than 1 acre. Align with zoning definitions. Okay, I guess this is important. You know, it's a dry lot agricultural. If it's not agricultural, then nothing, it doesn't matter anyway. But anyway, and does it comply with setbacks, and so on. And finally, get a letter of support, which the mayor asked for, I guess, Rita told me, and she got the letter of support from the carrier. That, sorry, from Beth, even more. And really nice letter, actually. So finally, oh, yeah, I asked for elaboration of the Ontario agricultural guidelines. And they're there for you to review. And so I'll summarize it here. First of all, fact that there is no minimum extent. The fact that you require 25 acres doesn't make sense to anybody who's thinking about it. If every aspect of agriculture, as defined in the bylaw, requires a lot size 25 acres, then large areas of the township, which are zoned rural and are smaller than 25 acres, would be prohibited from being used for agriculture. Okay. But like that, it sounds ridiculous, right? But that's exactly what is trying to be done to us. Right? Because it's less than 25 acres, we're not allowed to use it for agricultural use. Okay. I make my point here. If the 10 hectare rule is to be used to prevent the heath slip from having a dry lot, then we respectfully submit that every other landowner in the township be subject to the same rule. We go around and find everybody who had a 10, less than 10 hectares, less than 25 acres, and is growing corn on it. They are outside of the rule, but they are breaking the same rule that you say we are breaking. And they need to go through this whole procedure. So in summary, the purpose of the 10-hectare rule is to comply with the Ontario guidelines that are intended to stop large farms from being broken up into small parcels, which are not sustainable as farms. It is not to prevent a landowner from using a smaller parcel for agricultural uses. The 10-hectare is only applicable to Severton. Using this rule to restrict the use of our property is a misinterpretation of the bylaw. There is no minimum acreage requirement for rural zone property to be used for agricultural purposes. It would be ridiculous if the 10-hectare rule was applied to the rural zone land. In that case, many islanders who carry out agricultural activities on their rural zone properties would be out of compliance and would require an amendment to operate. Of course, they are not out of compliance, and neither is our dry line. In fact, there's no need for this bylaw amendment at all, if you think about it. The only thing that we really need to do is meet the setback and odor control regulations. And those regulations are actually in the Ontario regulation. I don't know, can I ask him, you don't know? And do we need to them?
I mean, I did do the calculations and, it's nuanced, but, I don't want to go into this whole answer here, but the minimum distance separation does not apply to, open shelters. It does not apply to like horses or dry lots. What it applies to are, agricultural buildings or manure storage facilities, right?
Yeah.
There are no buildings on the property that would qualify under minimum distance separation. The only one would be a manure storage facility. However, under the guideline that we use to calculate setbacks that are provided by us from OMAFRA, if that is considered to be, if the manure storage facility is considered to be temporary, then the minimum distance separation formula does not apply to it, right? In fact, when I did do the calculations based on those specific structures as if they were barns, those buildings did meet those minimum setback requirements. The minimum setback requirements are also applied to only what's called 5 nutrient units. In this case, this translates to a minimum of 5 horses. So the calculations that I did that showed that the buildings meet the setback from those sensitive land uses were in fact done for 5 horses rather than 2 on buildings that MDS guidelines don't even apply for. So long story short, minimum distance separation is not a concern on this property.
Thank you. All right, so our dry lot meets or exceeds all of the regulatory requirements, even though technically there is no need for an amendment, in my opinion. Given that we've come this far, we ask the council approve it. Thank you very much.
Thank you. Do we need to go to council first before we hear from anybody else in the community?
Any response or anything like that, or like?
Yeah, I think it'd be good to clarify. Yeah, for sure. Thank you very much. So through the mayor, I'm glad that AI was kind of brought into this discussion because it gives me an opportunity to highlight how AI is sometimes not a good tool to use for nuanced issues. Part of the statement, there's 2 statements here that were made. Number 1, minimum lot size applies in the context of lot division so that you preserve agricultural land. Correct, 100% correct. On the other side of that, though, minimum lot standards do apply when you're establishing a new use on an undersized lot of record, or any lot of record. So if you have a vacant lot, you have to, demonstrate that, if that lot is undersized, that lot was, created legally for the purpose that it was created for, and then that way you can establish, a use on it. So if you had a lot that is less than 25 hectares, it was created for the purposes of agricultural production. Before the zoning bylaw came in effect, you get what's called grandfathering status or existing use status, and therefore you can continue that agricultural use. If you are looking at establishing a new use on a property that was created for a rural building lot, for example, for residential purposes, you either need an exemption in the zoning bylaw that specifically states that you can establish an agricultural use on an undersized lot of record, or you have to simply meet the minimum lot standards that are outlined in the zoning bylaw. So it's one thing I will say for council's sake as well is that when I sit in law seminars regarding land use and the use of AI tools, what we are constantly hammered with is that do not use AI tools to interpret the zoning bylaw or to interpret official plan policies, because those things are nuanced. And when those tools are used to interpret various documents, they often make mistakes. And quite frankly, I use AI for a lot of my work. When it comes to summarizing documents or stuff like that. If you don't know what you're looking for, if you don't know the nuance behind it, AI spits out information for you very confidently. And unless you know the details behind the documents that you're reviewing or the issue that you're dealing with, it's very, very hard to figure out whether or not what AI is telling you is a fact or not fact. So I respect and I appreciate the comments here. However, I'm of the opinion that that is not the correct way to interpret this.
Okay, make a couple comments on that?
Um,
No?
let's have the discussion of council first. Thank Councillor Ackland.
First off, I just, Rita, I'm a bit upset. I never once said that you were okay to keep the horses there.
Okay, Councillor Ackland, it's a
Oh,
discussion of council.
yeah. So, just to be clear, I never once said it was okay to keep the horses there. I am not the council. I'm just a person. It hadn't gone to council or nothing. You had one horse there. Now we're talking two horses. You had me move a few rocks. I didn't know moving a few rocks was gonna be the intentions of using it against me and against council to gain whatever. Very upsetting, very upsetting. At the end of the day, I listen to the people around me, and if the people around me don't want the horses, they don't want the horses. Secondly, I was there when Yvonne, our old CAO, had asked a question and we all asked questions about whether you could have the horse or not, and you were told no. And then it went on to our next acting CAO, and it was the same thing again. Apparently you did tell me some Jason guy came down, gave you approval, and I asked you if you had a letter, and you said no. So, and I'm like, well, he doesn't have the authority, and I know what I told you. He doesn't have the authority to tell you yes or no, because he is not council.
Did you tell me?
Okay,
I
Councillor,
did tell you.
Councillor.
Yes, yes. So at the end of the day, I did not, to be clear, I did not tell you it's okay to keep the horses or any kind of horses or whatever. And agriculture in my books falls under beef, sheep for wool, corn, hay, stuff like that. Not keeping family friends. You know what I mean? Like, I don't think I can run a dog kennel in my yard, nor do I want the next person beside me run a dog kennel or 5 horses beside me, or whatever they might decide after. If we did decide as council to approve you, means the next person can do it beside any given person in this room. And if we set a precedence today and approve you for something that anybody else could do, it's gonna be bad for everybody. You have done a lovely job down there,
Counselor,
but at the end of the day, I think we did say no.
try to.
We did say no, and I thought you were told straight up that, and Marcel had went there a couple times. I was understanding, cause I did chat with him, and I was under the understanding that he told you no. And then you just continued to build, and yes, it's beautiful. But on a second note, I can honestly say Justin Hughes, North Shore Road, 6 acres of land. Full out system like yours, probably even better than yours, and they shut him down. Boom, you can't have it. He never ever brought his horses back, and the land still sits there with this beautiful stable. And he can't even have his $100,000 horses in it. So at the end of the day, it's. We have to do what we have to do, cause the bylaw states. You can't have that.
I disagree.
Counselor, you mentioned that this came before the council before. Do you have a date when this came before the council?
I didn't
before?
say it came before council,
Oh, it
I just
didn't?
said, no, it was, it
did not
was
come.
brought up by our old CAO, and I went down and looked around and whatever, and you know,
So it's never been brought to
No,
council?
not-
This is the
not
first
that
time.
I remember.
Okay, thank you very much. Okay. Deputy Mayor.
Thank you, Mayor. So a question first off for clarification with the CEO. Bylaw complaints are confidential, correct?
Correct.
Yeah, so you made the statement that you weren't told who the complaint was. That's consistent with the current procedure. Anybody can issue a complaint, it's filed, it's followed up on, but unless I think it goes to
Through you,
Laura.
Madam Mayor.
Mhm.
Unless we appear before court and the complainant is summoned to the court to testify. That is the only way that the name or the identity would be released.
Thank you. So a question from Seth, if I could. First of all, thank you everyone for coming. These are public meetings, they can be a little tense, but this is why we have public meetings to make sure we get the information out there. So thank you all for coming. A question, it was suggested in your report, a couple of times that you would need to get council approval. It sounded like you never moved forward on that, so that's, guess that's a stumbling block in terms of issue going forward, asking for official, council approval to the zoning change, so that you could move forward. So I'll get that on the record. The other is, have you considered, there's lots of agricultural land, lots of farmers. Have you considered approaching other agricultural land owners to work with them to develop the dry lot area that you require? So did you look for alternatives as opposed to the current less than 1 acre lot?
Why would you?
I'm sorry.
Why would you? If you think that the lot you have
Okay,
is sensible.
that's just a straight yes or no.
So the answer is no. Oh, thank you.
No, okay, that's fine.
Just to clarify, she did look around for another dry lot.
We,
Okay.
what
A lot.
about, okay, let's keep this. Is there a yes or no response from you, Rita?
Not to go to vacant land, no.
Okay. All right. Okay, Councillor Holton?
I guess that was one of my questions. There's quite a bit of agricultural land. You've done a beautiful job developing it. It's just, to me, that's the total wrong place to keep livestock. I had this issue close to my place. I have a farm. It's just not the place for a horse. Sorry. That's my opinion.
Okay. Councillor Jablonski?
Thanks, Madam Mayor. I agree, like, you did a great job. I actually, contrary to comments, we did actually drive by and take a peek. And the property is quite nice, well set up. I guess I have to agree with on the council that if we set a precedent here. 1 acre or less, 0.83, it's not even an acre. We open the door for other people to say, oh, they can do it. I mean, agriculture to me is, if someone wants to grow a few stalks of corn in the backyard or grow a garden for their own personal use, have at it. I agree the 25 acre requirement is not required then. But to have a large animal. And I know it doesn't require 25 acres to run free and have a great time, but I think you're affecting the laws, but the fact is that if you have 3 or 4 other people wanna buy horses too now, on Waker lots, this is gonna start cascading down. I love them, don't get me wrong, my heart goes out to you, I hate when people talk against it, but you gotta obey the zoning bylaws. That's the problem, is it gets out of hand. So I just wanna make that comment, but, no, we have seen the property, it's quite nice, I agree. Thank you.
Well, good news is that we are not AI, so we get to use our brains, our hearts, and our common sense in that. And I was very pleased to see the letters of support even by the veterinarian, and the point being that that is more than enough for horses of this condition. So with that, I'm not a veterinary expert. I see that the nearest neighbor is A, the township, and we don't live down there. B, the next door neighbor, and that doesn't have an issue with it. And it seems to have passed the muster for everything from being safe for the horses to odor control and the dedication that, and the fact that it is very proximal to your home, and that tells me that it makes sense. I spent 30 years up in the Waterloo region with a lot of Mennonite farmers, many of them very large, and many organic farmers that were very small. And that I remember being in particular that had less than a 2-acre lot that made her entire living on growing garlic. Now we have things called vertical farms. And greenhouses were also mentioned in that. There's a lot of ways agriculture, bees. People keep them in their backyards, whatever. And that's so. I did my research and I actually visited the property and that. And I'll side with the expert on that, that is a lovely piece of land for horses, and they're lucky to have you advocate for their life quality. That's so, this is not a decision-making meeting, but I'm more than willing to listen to anyone that has pro or other complaints. I have yet to hear a complaint from a resident. No one has phoned me or emailed me and that regarding this. But I have done the investigation and I am impressed with the support for it, so. If there's anyone present here now that'd like to come forward, state your name. And I see Chief Quinn would like to say something, yes?
So through you, Madam Mayor, to the members of council, and just for the public record, it needs to be clarified and both today in the verbal report by the applicant as well as the written submission, it speaks to having been given approval by Justin Kane, and then my name is also mentioned as well as Councillor Ackley. At the time, Justin Kane's role was building inspector, and not a bylaw officer. My role at the time as acting public works lead was to go on behalf of the CAO, Yvonne, to assess the request and to report back. So I reported back to the CAO. I did not provide approval, nor did I have the authority in those days, nor do I have the authority today to approve. So no approval was granted verbally or in writing, but there was a report back to the CAO, who then, my understanding, responded with denial of the request. So I submit that for the public record.
Okay, do we have a public record that Yvonne Roberts denied this request? Because that's hearsay from Mike.
Through you, Madam Mayor, there is a report that I have on file with regards to this property where Ms. Rivera had contacted the bylaw enforcement to attend the property. Based on the report back, a letter was sent that the horses must be removed from the property. Or the horse, sorry, my apologies, the horses.
So that was issued by Yvonne
Correct.
and not followed up any further.
I don't want to speak to that ultimately. I would have to review the file.
Okay.
Rita talked about that in
If
Okay.
anybody that wants to make a comment, if you can come to the chair and tell us your name and your address. Come to the chair. Thank you very much. Make sure people don't hear it, but you can just pull that chair out of the way. If I was sitting too long. Thank you.
I'm Fran Fleming, and I live at 27 North Shore Road. I get emotional, sorry. I have known Rita for 17 years. And she's always loved animals. And when she got these 2 horses and she worked her arse off cleaning up that property, taking away all the grass so the horses would be able to stay there. The horses love her. And I gotta tell you something funny. So one day I was visiting Rita and Whistler was out. And he came behind her and he nibbled on her shoulder and she turned around and she's, "What are you doing?" And that horse smiled. His lip went up and his teeth showed. It was just wonderful. And the little one, the little pony, all she wants is love. And that's what Rita gives her. I'm sorry, but I get really emotional. I can't help it. It's the way I am. It's the way I'm built. Anyway, but those horses had the most wonderful place to stay. They love her to pieces and she gives them their all. And she keeps that place so tidy and so clean. She always cleans up the manure. And she just works so hard. And I would just love for her to keep those horses. They bring something to you. Animals are wonderful. They love you to pieces. And her horses love her. Thank you. Sorry about that, Brian.
No apology needed.
Thank you, Peter.
And go next.
I just have a good word. My name is Peter Fleming and I'm Fran's husband. And I'm at 27 North Shore Road too. And we have a property at the end of Pickett's Lane. And I do have occasion to travel on a regular basis up and down Pickett's Lane. And I think we are all in agreement here that Rita keeps her place immaculately and she does a wonderful job. And I think the salient point here is what you have made, Mayor, and that is that she has met all the criteria. And she has professional opinion that reflects that she is in compliant. And based on that alone, I am in favor of Rita continuing to have her horses there.
Okay, thank you. My name is Mary Arnold. I live at 1796 Highway 2. I want to address the issue of a precedent being set here. Because in fact, we are talking about a change to the bylaw or an amendment, temporary amendment to the bylaw, not whether or not it's in compliance with current bylaw. But in my mind, if a precedent is being set here, the precedent would be that if you meet the kind of standards that Rita has in making that her piece of property appropriate for the housing of 2 horses, then yes, you can keep 2 horses or 2 bison, I don't care, whatever it happens to be, if you meet the standards that she has in preparing her property. Okay. Yeah, Nor?
Teresa Westfall, I live on North Shore.
And right up, because we got the owl.
I only have a question for
You
clarification.
need to come up because we got the owl, was up.
All right. This question should have come earlier in the proceeding. It's just a question of clarification.
Teresa, what was your last name again?
Westfall, I
Okay.
live on North Shore Road, so I don't live on Pickett's Lane. So I just have two questions. Because it wasn't in the documentation provided nor in the presentation. My question is, specifically, how many farms and stables were approached to see if they could accommodate your needs, either on the island or on the mainland? And my second question is, because you mentioned how important engagement was, and the fact that, your neighbors, this is gonna impact your surrounding neighbors. Did you approach personally, each neighbor on Pickett's Lane? Because it's a small road. So I didn't know if you engaged each neighbor personally rather than just in the email. So it wasn't in the submission and I was, just looking for additional information.
Right. The first one was what, sorry? Oh, what did I look for?
Which stable and farms did you approach and how many? And you said it was a 9-year period. And the second question was, did you engage each neighbor on Pickett's Lane to
Okay.
inform them?
For the first one, Kingston and surrounding areas, that goes as far north as, I was in Bunbury at one time. As far west as, Pasadena. Over towards Sealy's Bay, over towards Lansdowne. And all the way through. These are not private boarding facilities that I don't know of. These are open boarding facilities that actually are advertising or by word of mouth that would have something, but they don't have dry lots. They have something called seasonal paddocks. And seasonal paddocks are used in boarding facilities to accommodate horses during winter and spring months when the grass is unusable, when they don't want to, when they want to keep the integrity of the pasture. So horses transition in and out. They're not meant for permanent residents. There's no shelters on them and it becomes a mud pit.
And you indicated that there was one farm on the island that you did have a relationship with,
Oh, Mary
but
Monroe.
you didn't approach others.
Mary Monroe, I actually boarded with.
But were there any other farms on Howe Island that were able to?
No. Because you have to have it, it's so convenient to have a horse on pasture. It's easier for the barn manager. They don't want to be wasting their time, or time is valuable. To be with special needs horses that require the maintenance of the dry lot, and then the medication, and then a hay-only diet. It's much easier to throw them out in the pasture or give them hay 24/7. But a horse like Whistler who has that is a life-threatening thing, because grass could be rich in starch and sugars, or the hay can be rich in starch and sugars.
And so my second question
Yeah.
in terms of engaging, because I forget how many houses are on Pickett's Lane.
Well, there are 9.
No, so did you have the opportunity to talk to all 9 neighbors about?
Actually, I sent the email and most of the neighbors came down and saw me, except for 2. The rest were supportive. I asked for comments or concerns to please come and see me. Don't forget, this is a crunch period. I've only got a month. The horses from Mary's are coming back in May 1st. I've been told that they need the dry lots at Mary's place and I need to find another spot within, weeks, months. I have a forest out in front of me. I've already looked at other dry lots in the area. There aren't any. And it's not just the dry lot, it's the hay. Not all farms provide hay that is free of alfalfa and legumes in their hay. So it's a kind of a double thing going on. So, yeah, with the time period that I have to get the dry lot up and running, get rid of the forest, do things, and I'll address Bob and Mike's comments after. And so for the concerns for the residents on Howe Island, yes, they came and saw me. except for two. We support you with this. Like to meet the horses, our horse when he comes, you know.
Okay, great.
For me, it was get the approval. It was a verbal approval. From the planning department, I don't know who else, Justin spoke with, but, and then concur verbally with, council. And, I had not received any complaints, any letters saying, no, you cannot do this. Nothing. If there was something done within internally, I have not.
Thanks. You answered my questions. Thank you.
Okay. Anybody else from the public? Name and your address, please.
Kelly Chamberlain, 903 Howe Island Drive, Howe Island. So I grew up on horses, with horses all my life. I literally have pictures, I'm in my diaper and I'm holding a horse. I have horses right now that my dad left me when he passed away, and one needs to be on a dry path. I have 70 acres and it's agriculture, but I can't bring my horses because when I built my house, they told me I can't have live animals there anymore. I'm too close. But yet, the existing houses that are right by the barn are there. So I have to pay for my horse to be in Verona. And I have to travel there. I'm fine with that. Even though I have land that's zoned agriculture, I obey by the rules. They said no live horses, no cows. I don't. You're zoned residential.
No.
What's it zoned?
Rural.
Well, it's rural. It's not agriculture. I have agriculture land. I have crops on it right now, but I have no live animals except for my kitty cats in my house. I pay to have my horse in it. She is old too, and I love her. I was there when she was born, but she is not with me because I'm going by the rules. You were told that you could not have the one horse, but yet you brought in another pony, and I get it. Horses want to be in a group. They get sad, depressed. I get that point. But when you were told no for one horse, you brought in a pony then, so then it's two. And I understand that you are cleaning up after the horse, but you don't clean up immediately, and there's still urine, and you can't scoop up urine. You just can't. That will still require flies and other animals to be around. It just will. You can't 100%, unless you're putting something underneath the horse, like a plastic catch-all to catch everything, which they do make, but they're not on those horses. So that's just, so if you're gonna let her on a little acre of land, it's not even an acre, have two horses, why can't I have some on 70 acres? And I do have partially agriculture.
I don't know. Have you asked?
No, because I abide by the rules. I was told, fine, all right.
Who told you?
The township, when I built my house, I signed a paper that said I would not have
When was
animals.
that? It never came before this councilor.
No, because they told me no when I needed to build my house, so I said, yeah.
I'm asking, when did you get told no? What year was this?
2006 and 2005, throughout that winter, we started building our house and we were doing all the paperwork. And at that point in time, the paperwork would have been in my father-in-law's name. Because after we built the house, we switched everything back over to my husband's and my name.
Not a graduate, but,
Yes.
Kelly, would you want to set up a meeting with me so we can discuss potential?
No, my horses are good where they are and I abide by the rules.
Okay.
It's just,
No, but this is the point.
I'm fine.
No,
but-
the point is that the applicants have come to council.
What I'm
Ask
saying
for
is,
variance.
if you do it for one on less than an acre for two horses,
But-
then it might keep.
Right, but what I've just heard from the senior planner is, would you like to have a meeting with him?
I'm gonna see how this flies first. Okay. And then we'll see. Also, for proper health of an animal, especially a horse, it is deemed 1.5 to 2 acres, so properly have physical activity for a horse. So now there's 2 on less than 1.
And yet we have a report from a esteemed veterinarian.
You have enough
This is
cash,
secure.
you can get anything written.
Oh, wow.
That's,
I could go right now and get a vet to say the same thing. than is for horses. I know I could.
Okay.
Anyway,
But that's just the way it is. And if you think I mean, that's it, but I grew up with horses all my life and I care about them. And I don't agree that a lean-to is sufficient enough for two horses for year round.
Okay,
can I respond to this?
no, I don't think
No,
so. I don't think
okay.
it's gonna be anything added to it. We have the expert opinion and we have her opinion and that's that. Yes, come forward and state your name and your address,
Yes,
please.
James, 19 Pickett Lane, next door to Robin Reed's. I have been a horse owner and rider for 60 years. I have other friends who have horses who are insulin resistant. And so I understand the dilemma. I also understand that if Reed is unable to keep this horse, he'll have to be destroyed because there is nowhere for this horse to be. As far as Kelly's statement about the urine, urine happens from any animal, whether it be cattle, deer, fox. That's not an issue. I live next door. Occasionally you can smell it. It doesn't bother me. I also believe that, people who, make statements about what they think a horse needs in this particular case don't have the education to understand what an insulin resistant horse requires. Like someone like Rita, who's been studying this for as long as her horse has. She blows my mind with the information that she has. And she has a very close relationship with a veterinarian. So when I just wanted people to understand that I live right next door and it doesn't bother me. It's a beautiful, I mean, her yard is nicer than my house. And I really enjoy bringing my granddaughter over to see the horses. And I really hope council will make this amendment. And I also am curious about the constant repetitive statements coming up about a precedent. I have a horse, I've had horses, and there's no way I would go through every use to look after a horse. I pay someone to do that for me. I don't have the sustenance and strength to look after a horse. My horse is not insulin resistant, so I can board in lots of beautiful places. I don't understand why people with farming backgrounds think that having horses on a lane, and in a situation quite as beautiful as hers, would say that it's not appropriate there. They've obviously not had horses and understand the beauty of a horse. The aesthetic of people coming off the ferry and seeing that lovely place. Do you own horses or do you own cattle?
Cattle.
Yeah.
And
Okay.
if it may, Madam Mayor, since you addressed me, I appreciate the cows just as much as you guys appreciate horses. I mean, you can laugh if you like.
No.
But it's not fun. I think just as much of them, and I mean, I just got a text while I'm in the meeting about a decision we have to make with the cow. So I understand about it, but I have 150 acres, my land is zoned for it. The rules are rules for a reason.
Madam Mayor, if I could respond,
Actually, I'll go to Councillor Ackley first. He had his hand up.
Again. Nancy is the next door neighbor and she also owns a horse, correct?
Yes.
But you have your horse kept elsewhere
Because she's not insulin resistant.
and she can eat grass and
Yeah.
whatever and so forth. And so on. And just one other technical thing here, on Highway 2, did you not board at St. Lawrence Farms?
No, I did.
I thought
They
you
don't
boarded there.
Oh,
Yeah, at Westonburg's.
no. No, that's.
Oh, you boarded there. I was just checking.
Okay, now, Deputy Mayor Saunders.
Thank you, Mayor. For the record, I have owned horses. My daughter rode competitively with horses. My granddaughter's currently on a competitive series, equestrian series. So I do appreciate horses. I know horses, so I somewhat object to the fact that comments are made about I don't understand horses. So for the record, I understand horses.
Okay. For the record, I don't own a horse. But I've always gone by a saying that my father told me years ago. You can tell a lot about a person on how they treat a dumb animal. And I did go to the paddock and I was very impressed. You've shown me that professionally speaking, this is the acceptable care beyond acceptable care and that. And I don't have a problem with it from that point of view. Different applications of what makes a farm. I know, I believe it's 50 acres and that if you're trying to get a tax credit on it. 50 acres is the concept in the past of keeping the farm viable. But as I said, farming is changing a lot. Farming can be bee farming. Farming can be your garlic. Farming can be vertical farming and that. So I think that the province needs to catch up on a fair bit. And there is a nuance all the way along. And this particular case seems quite clear that this is a unique set of circumstances for a couple of very unique horses. And it meets and exceeds any standard by professionals, so I truly don't have a problem with it. And that's the beauty of having a council that can think and interpret the rules and then make a conscious decision as to what should be applied and what isn't. And as it is, we haven't even got the recommendation from planning because this is an information meeting. And that, so I look forward to the recommendation. And one more comment, Councillor Ackley.
Madam Mayor, you'd be comfortable with the next door neighbor having a horse beside you in the town?
Actually, not far from my place.
No, next door.
Yep.
So that's what we're here about.
Yes.
Some of the people in the surrounding area.
Actually, that's the point. The only ones that I've heard that had any complaint aren't even on Pickett's Lane.
Well, that's the fact here, because those people don't want horses in the next door neighbor's yard.
Well, that's,
So we have to take that all in, not just the one person that lives beside. We have to take the whole factor, the whole island
Councillor,
in.
if we all
So-
listen to the NIMBY or not in my backyard group, nothing would move forward. So
And again, Madam Mayor, I think we should let the rest of the people
Counselor?
speak.
Counselor? I just wanna ask the planning and that, what are the current rules and that for engagement? For planning changes and that, is it not 120 meters either way?
Yeah, Madam Mayor, yeah, that's correct. I also want to make a comment regarding precedent setting, whatever, if I can do that. Okay, so there's a lot of discussion about precedent setting. I just want to clarify that if a decision is made on one particular property, whether it's a minor variance or a zoning bylaw amendment, that is not a blanket precedent that's set, and then that same rule applies to every single property in the township. From a legal standpoint, I'm not a lawyer, but from a legal standpoint, planning decisions are not legally precedent setting, meaning that somebody cannot simply come to township council and say, well, because you approved an application in this context, you have to approve it in this context. There's no, each application is addressed on its own land use analysis and based on its own merit and its own unique set of particulars. So I just want to clarify that. Although precedent is important in the context of the way a decision is made, the logic that's used in coming up with a recommendation or finding a solution, the decision itself does not render the council to basically make the same decision on other properties all throughout the township. So just want to put that on the table as well.
Thank you very much for clarifying that. Okay, so anyone else from the community? Anybody online?
Yeah.
Don't see any hands up. Okay, seeing none. We have a motion. To adjourn the meeting. To adjourn the meeting next. Okay, motion to adjourn.
Moved by Deputy Mayor Saunders, second by Councillor Duwoniki, that the public meeting of council held June 23rd, 2025 adjourns.
At 11:28.
All those in favor?
Thank you, Carrie.
Is it your meeting? Oh, is it?